Sandy, are you ready? Great. All right, let's get on the record. This is 2021 CV356515. It's still Baldwin County against DBHDD and the commissioner, Mr. Tanner. Are we on our second or third commissioner during the duration of this litigation?
Second.
Second, okay. And we are here to work through I'm going to say the states, I know it's the department, but the state's motion to dismiss plaintiff's third amended complaint, which adds some additional bases for a mandamus claim to seek to compel Commissioner Tanner, not directly, of course, but to get Commissioner Tanner and his department to engage in upkeep and maintenance of buildings in Milledgeville that are state buildings. Can I have the appearance for Baldwin County?
Brandon Palmer on behalf of Baldwin County, Your Honor.
How you doing this morning, Mr. Palmer?
Pretty good. How about you, Judge?
I'm all right. No Mr. Welch today. He's letting you fly solo?
That's right. Yes, sir.
Excellent. And on behalf of the department?
I'm Jonathan Legel.
Hello, Mr. Legel. How are you?
Very well, sir. Thank you. How are you?
I'm all right. So you all had, and I don't know if it was Palmer or Welch or both, but you all had oral argument recently on the declaratory. What's the other half of the lawsuit?
That's the breach of contract.
The breach of contract. That's right. Breach of contract. That is behind you now. We'll await ruling on that, but we'll press forward with the mandamus claims. And I'm going to share with you my brief understanding, or I'll show you briefly my limited understanding of what's changed and where we are. And then I will invite Mr. Legel to come on up or from his spot right there to further articulate his position. And then Mr. Palmer, of course, I'll hear from you. But what's changed is originally the mandamus effort sought to get Commissioner Tanner et al. To comply with SPC 01, which was an internal policy that set some guidelines as to how Central State Hospital buildings, and it wasn't specific to Central State Hospital, but the buildings needed to be maintained. Added to that now are some additional requirements that Baldwin County believes obligate the commissioner to follow, that would lead to maintenance and upkeep of the Central State Hospital buildings. It includes some Title VIII statutes that get into the International Fire Code, Building Code, and Plumbing Code. And there are some corresponding ordinances from the city of Milledgeville. And there's a little disagreement about whether the sides are saying you have to comply with them or if they simply set a framework, these Milledgeville ordinances. But the thrust of what we're doing today is working through the Attorney General's team's argument that these mandamus claims should be dismissed. There's a sovereign immunity claim, and then also an argument that there are alternative adequate remedies. And so there's nothing to be done on the mandamus side. There are other channels through which the county should move to get the relief it's seeking. I think that's more or less what we're doing today. But I will admit to often being outflanked by the lawyers on both sides as they have dived much deeper into Title VIII and other things like that concerning what obligations might exist for the department to maintain the buildings on the campus. So with that, as always, Mr. Legel, I'll start with you, and then Mr. Palmer, I'll hear from you.
Thank you, Judge. I think as a preliminary matter, the court has a grasp of what we're here today to talk about, and none of the things I heard surprise or do I disagree with any alarm or do I disagree with any of them. Okay. So I think we're all on the same page. Generally speaking, I think this particular motion does just deal with the third amended complaint, and we can address it as three issues. One, are the International Construction Codes law.
When you say international construction codes, those are the three I's: IFC, IBC, and IPC. They're subsets of the ICC?
That's correct. Yep.
Building, fire, and plumbing.
That's correct.
Okay.
And yes, sir, that's entirely correct.
Okay.
ICC is the International Code Conference, the private organization that drafts and creates what I like to think of as model codes.
Mhm.
And then those model codes are adopted by jurisdictions and frankly contractors to make sure that buildings are put together correctly.
And do you believe that the state of Georgia through Chapter 2 of Title 8 has adopted the ICC, or at least the three, the F, the B, and the P of those?
Yes, Your Honor, through Title 8, the state of Georgia has adopted those as laws, but not with regard to state-owned buildings because the state hasn't waived, we've talked, sovereign immunity on those issues. But yes, there's no dispute that Title 8, Section 2, well, basically Title 8, adopts those codes. So that's correct. And they apply to privately owned buildings and other properties in what we call a statewide application. That's a quote from the statutes. But we don't believe statewide application demonstrates a waiver of the state's sovereign immunity. We don't think that this chapter waives the state's sovereign immunity. And in fact, we think that there's a different avenue that can be pursued to gain enforcement of these codes if required.
Okay. And we'll want to explore that because that's my main exploration twofold with you is the sovereign immunity piece and then the alternative adequate remedy. But it sounds like you're prepared to cover those. But you said issue 1 is ICC law? And then you said, yes, it is, because it's part of Title 8, maybe Chapter 2, but more than Chapter 2, it's part of Title 8. Is ICC law that applies to state-owned buildings?
May I clarify that?
Okay.
The ICCs, the international codes, by themselves are not laws.
Got it.
Okay. They are laws when they are adopted by a jurisdiction. So, for instance, they've been adopted, certain of them, the IFC, the International Fire Code, has been adopted by the city of Milledgeville. That is a law applicable to the city of Milledgeville. The ICC, the IPC, the IFC have all been adopted by the state of Georgia, so they are applicable through the mechanism of the state's adoption. Okay.
But just the book, if this was the ICC, that's fascinating, and it may be a great reference tool for builders and for Milledgeville, but it's not law, only if it has been adopted, and then it would be law as applied through whatever provisions in local ordinances or state law contain them.
That's entirely correct. Yes, sir.
Okay.
And we cited a couple cases that demonstrate that the ICCs are not laws in themselves, but we do not dispute that Chapter 8 makes them laws with regard to statewide application, with the caveat that I placed on sovereign immunity.
Got it.
So, but then the second one is, has the state or DBHDD waived sovereign immunity with respect to the City of Milledgeville Ordinance or Chapter 8? We believe the answer to all of these questions is no. The codes themselves, without adoption, are not laws. The City of Milledgeville's ordinances do not waive the state's sovereign immunity with regard to these codes, and the state's adoption of these codes in Chapter 8 do not waive the state's sovereign immunity with regard to its state-owned and managed buildings.
Before you go further, I think, as I understood Mr. Palmer's response, the county is not saying that the state has waived sovereign immunity as to any ordinance, because cities can't pass an ordinance and say, haha, state, you're subject to that. There would be no sovereign immunity. I think they were relying on the ordinances, I'm going to use the wrong words, but more as exemplars, or here are other obligations that exist for municipalities and whatnot. But I don't, am I correct, Mr. Palmer? You're not arguing that the Milledgeville ordinances, by their passage, waive sovereign immunity for the state?
Judge, the only sovereign immunity that matters is the claim that's being brought. What is the claim? It's a writ of mandamus. Sovereign immunity doesn't apply to a writ of mandamus. The Milledgeville Code, the statutes, and the fire commissioner's rules and regulations merely adopt the international code, which create the duty. The duties are spelled out not by the statutes, not by the ordinances, but by the code. What does the code? Those are the duties. The only sovereign immunity issue has been well decided in the state, and that is it does not apply to claims for writ of mandamus.
Okay. You got ahead of us, and you're going to be able to argue that more. So I'm going to turn back to Mr. Legel and have him keep going.
Just to clarify Mr. Palmer's point, what we might be talking about is a difference between a 12B1 motion to dismiss and a 12B6. And for clarity, we've only brought a 12B6. This is not a 12B1 motion to dismiss. And I like to think of it through the example of a mandamus gets us into the courtroom. It is subject matter jurisdiction that puts us in front of you. But the parties, the plaintiff, still has to set forth a claim. Failure to state a claim is a 12B6 motion to dismiss. We do not think that the mandamus claim waives sovereign immunity for all claims that would state a clear legal right of relief. And we'll cite to the court's earlier opinion in this case and a case that Mr. Palmer cited, Kelsey versus Department of Community Health. It is 352 Georgia App 716. The summary of that case is essentially plaintiff brought a breach of contract claim against the state, and it brought some constitutional violation claims against the state, and it brought a mandamus claim. The mandamus claim was essentially to enforce the breach of contract claim. And the court in Kelly, the court said that there was no breach of contract claim. The state hadn't waived its sovereign immunity for a written contract. Then at the last page of the opinion, it looks at the mandamus claim and it says, because there's no clear legal right to relief to the breach of contract, there's no clear legal right to relief for the constitutional claims, there's no clear legal right to the mandamus claim. That's the path we're going under here.
Right. And that there has not been a demonstration that Baldwin County enjoys a clear legal right to have these codes enforced.
Yes, sir. That's correct.
Okay.
I can give you another analogy, which would be if a mandamus claim was brought for a breach of contract. If it was a breach of a written contract, like in the Kelly case, and there was a valid written contract, the state has waived its sovereign immunity for that. Mandamus could be used to enforce it. Let's use an example that's slightly different, which is an implied contract. In an implied contract case, the state hasn't waived its sovereign immunity. So while there may be a breach of implied contract, there's no legal right to relief under that breach of implied contract. So you can't use mandamus as a vehicle to enforce an implied contract against the state.
So taking us out of the realm of DBHDD to pardons and paroles, assume for a minute that there was a legal obligation on pardons and paroles to review a sentence after 10 years. That's what at 10 years, you got to, in custody, you have to review. And it's now 11 years. Inmate X could bring mandamus against pardons and parole saying, hey, we're at year 11. You were supposed to review me at 10 because I have a clear legal right to review at 10. If instead the policy was they may review at 10, but it's subjective determination. They can look at the GDC records, how well have you behaved, what was the nature of your offense. Then to your argument, because you don't have a clear legal right to a review at 10, then there would be a sovereign immunity lack of jurisdiction to that lawsuit seeking to compel the board to review at year 11 because they hadn't at 10. Was that?
Your Honor, I'll freely admit my lack of knowledge on criminal procedure.
But I made it up.
Under your analogy, under your hypothetical, I think that's accurate. Yeah, I don't disagree with it.
Is that really the petitioner for the mandamus needs to be able to point to this legal obligation that exists for the state. This is mandamus against the state actor that exists for that actor to do the thing, or at least make the decision, because the decision could be, we're not granting you parole, but at least we considered it. Mm-hmm. But there has to be a right to the relief or action being sought. Otherwise, it's not waived. Unless there's a written contract, in which case you're enforcing the contract, and there's your right. Your set of rights would be compliance with the terms of the contract.
Yes, Your Honor, I agree with everything you said, but to clarify it, I think the clear legal right to relief in your hypothetical is clear because there's no sovereign immunity argument, whether it's the discretionary decision. The clear legal right is the right to have the review, as you said. Right. So I guess I'm agreeing with you completely. Yes.
Okay. Because I want to make sure I'm teeing up your argument the right way when I then explore it with Mr. Palmer, because the county is taking the view of people have always been able to bring mandamus actions to enforce obligations, and you're not saying I disagree with that. You show me the clear legal right. And if there isn't one, then in fact, you don't get to do that because there's that threshold requirement of the clear legal right that you're seeking to vindicate.
Yes, Your Honor.
Okay.
That's accurate. And then the next points that I'd like to make, and I think I can do this pretty briefly, are whether there is a clear legal right to relief under the third amended complaint. The third amended complaint brings, what we'll call brings the code through the city of Milledgeville's ordinances and tries to bring the code through the state's ordinances, whether the state has waived sovereign immunity for either one of those. And if it hasn't, then there's no waiver of sovereign immunity. There's no clear legal right to relief.
And why would not, and maybe you're going there, I know I often get ahead, why would not the creation, the passage of the legislation of 8-2-20, which has these state minimum standard codes incorporating components of the ICC, why is that not creating the legal right to relief? In other words, I, as the petitioner, am saying you obligated yourself, state, to meet these minimum standards. And look, I had my inspector check out building 7 at Central State Hospital, and the pipes leak, and the IPC says no leaking pipes.
Your Honor, the answer to that question is sovereign immunity.
Okay.
It is, first of all, the petitioner's burden to always demonstrate a waiver of sovereign immunity, and sovereign immunity is not waived unless, according to 138, the state is either named therein in the statute, or the law is so plain, clear, and unmistakable as to leave no doubt as to the intention of the General Assembly. And after reviewing Chapter 8 and additional parts, which I'll talk to you about in a moment, Chapter 25, it's clear that the state did not waive sovereign immunity with regard to its own buildings. This is, again, first of all, the burden is on them. The closest thing in Chapter 8 is the phrase statewide application, which isn't defined. The Court of Appeals has looked at similar things. What is a plain, clear, and unmistakable waiver of sovereign immunity as to leave no doubt? And for instance, in Board of Regents versus 160/90 LLC, they looked at the Trade Secrets Act. And in that one, the statute actually says government or governmental subdivision or agency. And they said, hey, even though you use the phrase government or government subdivision, that doesn't waive sovereign immunity.
You have to say state.
They had to say more than government or government.
Whatever that is. Okay.
Yeah. And then there's another one called Tricoli versus Watts, and that has to do with the state's RICO claims, or the state's RICO statute rather. And it defined an enterprise for RICO purposes as an enterprise including governmental as well as other entities. And the Court of Appeals in that one also said that's not a clear, unmistakable waiver of the state's sovereign immunity. We think the phrase statewide application is equally unpersuasive.
Maybe even more so, it doesn't say anything about governmental entities. It simply says these codes are to be applied statewide. You're advocating the position that Chapter 2 applies only to, I think you said, privately owned buildings. Well, we're gonna have to navigate that, but yeah, that, if you're correct about that, it couldn't create an obligation for state-owned buildings if it applies to privately owned buildings.
I want to be very clear that it doesn't specifically say state-owned buildings. It applies statewide application. So we're going to go with the Venn diagram of everything and then carve out the pieces it doesn't apply. Right. Statewide buildings are one of those pieces that doesn't apply in this Venn diagram. But it doesn't. And one of the reasons is there's a later chapter, Chapter 25, which has to do with fire services. And in the fire services chapter, there are a number of code sections, and they're not linked as well as I would like to have hoped. But essentially, Chapter 25, 25.2, we'll start with that, 25.2, 3, 10, and 12 explain how the process is supposed to work and explain who actually has authority over fire codes, building codes, plumbing codes with regard to the state. And it's not a private entity, it's not county, and it's not, and the state hasn't waived sovereign immunity. But the state can, but these codes can be enforced by the fire commissioner. And there's a clear administrative way to do that, which I'll explain in a moment. But that also dovetails with the fact that the state hasn't explicitly, clearly, plainly, and unmistakably waived sovereign immunity with regard to that. So that has to do with one of the two things I want to bring up, which is the state code section. And then there's the municipal ordinances themselves. And the court alluded to this earlier, is as a historical rule, and I never found an exception to it, city ordinances do not bind the state unless they specifically say otherwise. We addressed that pretty clearly in our brief, and I can do so again, but I feel like the court's got a pretty good grasp of it. So to the extent that there's an attempt to waive the state's sovereign immunity through the application of the City of Milledgeville Code, we think that that's also not a clear, plain, and unmistakable waiver of sovereign immunity. So assuming those two sections, those two avenues that plaintiff sought in his third amended complaint to bring a claim, those don't waive sovereign immunity. But even if they do, there's a second element in mandamus, and that's is there an alternative remedy?
Right.
Because mandamus is an extraordinary remedy, and the court is busy and shouldn't have to do things that can be pursued by other means.
Except in this case.
Except potentially in this case. That adequate remedy at law is defined as a legal remedy that provides sufficient relief to the petitioning party, thus preventing the party from obtaining equitable relief through the court. And in the Department of Human Services versus Addison, which we cited in our brief, when a statute provides a party with a means of review by an administrative agency, such procedure is generally an adequate review at law so as to preclude the grant of equitable relief. So if there is an administrative remedy available for enforcement of these fire codes or building codes, plumbing codes, things like that, then the court's equitable power isn't invoked. There is, in fact, and as I alluded, there's the state fire commissioner and the state fire marshal. And
but that's for fire, or does the commissioner, do the commissioner and marshal have the ability to enforce plumbing and the other C that was in the building code?
They do, Your Honor. There's two sections that I'd call the court's attention to on that. One is,
and those are two different people, the fire commissioner and fire marshal.
Yes, sir. Didn't remember.
No, you were going to answer my question, which is, well, what's the difference?
What's the difference? The commissioner of insurance is also the state fire commissioner.
Oh, that's right. So Mr. King is our fire commissioner. Right. He's got the things in the elevators that say this has been inspected.
Exactly.
Insurance and
so
fire.
Many people in it.
Yep.
Exactly right. And the state fire marshal is an appointee of his, a member of his department. And the state fire marshal and his inspectors are the parties responsible for every such building and structure owned or operated or occupied by the state wherever located. I'm quoting from OCGA 25212C, which 25212 in a broader sense explains which parties can enforce these codes. They say in large counties, they're enforced by the county. In smaller counties, they're enforced by the county or the city, but they're enforced by the jurisdiction, except for, and then it's section C, which defines the buildings that are not under the control of these prior entities, and that is hospitals, for instance, and all state-owned buildings. Those are under the exclusive authority of the fire commissioner and the fire marshal.
And one can petition either or both of these state officials to say, this is your building, and look at that. You're supposed to have doors that open outward on the outside for fire purposes, and it's clear this door opens inward.
Correct. And then there's actually a code section that says any person or any entity, such as a county or city, who would normally provide these inspections and enforcement of them, has the ability to inspect these buildings, including state-owned buildings, but then files that report with the fire commissioner and the fire marshal, at which point the fire commissioner and the fire marshal are obligated to enforce those codes. They are the enforcement vehicle.
And if they refuse to do so, then mandamus can be brought against them.
I would believe so.
You're not committing yourself to it. You don't want to say sovereign immunity has been waived, but it seems like the channel, rather than leaning on Commissioner Tanner, it would be leaning on Marshall Jones, whatever.
Right. Okay. Again, the court took the words out of my mouth. I don't want to commit to the fire marshal's duties, but I would have a much harder time saying that the fire marshal isn't responsible for the codes that he's adopted. And I would also say that the fire marshal is the knowledgeable expert in these codes. I want to go back to a second, and I don't want to forget to mention that he does cover all of the codes, not just fire. Okay. He covers plumbing, all that he covers, and I'm looking for a section. I'll find it for you.
Okay.
but he covers all of them, and he's the expert. He does this. He and his inspectors do this for a living. They, rather than have the court make a ruling that would be either very broad and say, follow the codes and hand me a book like this to do it myself, or have the court get very narrow and say, fix these plumbing traps and put these doors on the right side and things like that. The fire marshal does that. It's his expertise. He'd walk through the buildings and be able to do so. Going back to my forgotten fourth time, which is whether this fire marshal handles what we'll call all of the codes. He does. That is, forgive me.
Sorry, that's why you bring the red well.
Down. There are two sections that apply. The first one is 25213D as in dog, and it begins with the commissioners directed to investigate and examine construction and engineering techniques. And for the court's reference, this code section of the OCGA hasn't been updated in a while. It refers to something known as the American Standards Association and Southern Standard Building Codes. The Southern Standard Building Codes are the predecessor of the International Code Conference. It changed names about many years ago. But that's the authority by which the commissioner enforces all of the codes. And then the commissioner has actually adopted all of the codes in one of his administrative rules. And I don't have that in front of me, but it's cited in our brief. It's 123-.3, I believe.
Where does one find those? Are those online somewhere? I know I can get a copy from you, but if I'm Baldwin County wanting to see, well, did the commissioner adopt these codes? Can you?
Yeah, absolutely.
Searchable? They
are under the Secretary of State's website.
Okay.
All the rules adopted by all state agencies are procedural, all rules on state agencies for things like the Administrative Procedures Act are held by the Secretary of State, and they're provided to the Secretary of State. He makes them public. And I think the word search that I used to find them was Secretary of State Rules and Regulations.
Okay.
And it's 120, I'm pretty sure it's 120-3-3, but again, we cited, I know Mr. Palmer cites it in his brief as well.
Okay.
And then I want to go, having established that the fire commissioner has, exclusive authority to enforce his chapter, and that he manages state buildings, and that he has adopted and manages these different code sections. There's an administrative remedy for that. It's, again, we discussed it, the building, or the county or the city inspects a building, brings a report to the commissioner then goes out and inspects it. There's another section, it's 25-2-10, which addresses what happens if the fire commissioner or the fire marshal inspects a building and anyone doesn't like the result. And it says, should any person, firm, corporation, or public entity be dissatisfied with the ruling or decision of the state fire marshal, the right is granted to appeal within 10 days to the commissioner. And if the firm, person, corporation, or public entity is dissatisfied with the decision of the commissioner, then appeal is authorized to the Superior Court within 30 days in a manner provided by Chapter 13 of Title 50, which is the APA.
Which Superior Court? Where the location is? Or Fulton, because that's where the fire commissioner is based? I
don't know. I would like it to be Fulton County, but I don't know. I can find that out.
I don't know. That's a unanimous view, but okay.
But regardless of where it is, it's in the Superior Court. There's an administrative remedy here.
Yep.
And going back to my earlier point on the Department of Human Services versus Addison, an administrative remedy is an alternative remedy. Okay. Now,
well, alternative, and here, at least the way you're describing it, also sounds like adequate, because there are two A words. It's alternative, but also needs to be an adequate remedy. And the way you're describing it, it sounds, not having heard from Mr. Palmer, as pretty darn on point. If you are truly concerned about the well-being of the buildings, and the fire commissioner and his team are responsible for the well-being of buildings, not just fire, but plumbing, et cetera, that's the door you should be knocking on. And it sounds like there's already been an inspection that the county performed, because you already mentioned county can do their own inspections. Their concerns can be shared with me through this litigation, or they could be shared with the fire commissioner. And were he to do nothing or respond in a way that Baldwin County felt was insufficient or inadequate, then by golly, there is a way to appeal to a superior court, be that in Baldwin County or that circuit or here.
I agree with everything the court said, except for the fact that Baldwin County has already done an inspection. I don't know that for a fact.
Oh, I was under the impression, I may be mistaken, I didn't mean to impose any conduct on the county. I thought that inspectors working on behalf of the county had been able to identify some areas of concern, and because there's a reference, these are my notes, not anything you all submitted, that plaintiff's inspector identified some additional shortcomings beyond what we were talking about way back in day one. But that may mean just walking the grounds the way you and I could walk the grounds, as opposed to a formal inspection. I don't know. It's not critical. You shared with me, Mr. Lego, that local governments are able to conduct their own inspections of state-owned buildings if those state-owned buildings are within the jurisdiction of that local jurisdiction.
Yes, that's correct. And for clarity, my understanding, again, is that the inspectors, and we went out twice to look at these buildings, the inspectors were not the fire department. So to the extent the fire department, which is the entity under 252-10 that's allowed to inspect and file reports, to the extent they've done an inspection, I don't know.
No, I was alluding generically to inspector, and so it's probably what you just described. I didn't mean to suggest it was one wearing a red hat or a different kind of hat.
Okay.
Okay.
But other than that, I think the court's earlier point about the alternative remedy and the adequate alternative remedy is exactly what I was going to argue. So I think I've established both of those points. So for real brief purposes, the one thing I do want to say, which was raised in the response brief, has to do with a general premise of it's whether the international codes were considered adopted by the General Assembly, the State Fire Commissioner, or the City of Milledgeville matters not. We disagree. We think it absolutely matters because this is a 12b6 motion. To the extent they were not correctly adopted and to the extent they're not applicable through the state, it's not a clear legal right to relief. To the extent that they're not applicable through the municipal code, it's not a clear legal right to relief. To the extent that they're applicable through the state fire marshal, there's no reference in the third amended complaint about Chapter 25 or about the fire marshal. And I could be wrong here. I don't have a factual knowledge. I have no knowledge that anyone at Baldwin County has raised the issue to the state fire commissioner.
Right.
So,
which is a completely different channel that could still yield litigation in a superior court if the outcome of the commissioner's review and any actions he takes are deemed insufficient by Baldwin County. But that's not what's teed up right now. Here, the focus of the mandamus is the DBHDD commissioner, so Mr. Tanner, and not Mr. King.
That's correct.
Okay.
And I would say that there's an equally likely opportunity that if the fire marshal is, as the court said, teed up, goes down there, finds problems, makes specific notations of those problems, they'll be fixed. And it's probably I mean, the state does perform the duties instructed, as we said in a previous hearing, instructed to it by the court and the law. And to the extent that they're not, there is, the potential recovery through a mandamus claim against the fire marshal, or at that point, I guess it would be when you have a clear legal right of relief, when the fire marshal has ordered it, then I think there's a far greater argument that there'd be a clear legal right of relief against the commissioner.
Oh, right. Meaning either the fire marshal or the fire commissioner communicates to DBHDD's commissioner, hey, these are not our buildings, but we found some deficiencies. You need to fix those. That's where you're saying that the county might get traction with DBHDD, because the fire marshal's going to say, don't sue me. I agree with you. And my colleague over here is declining to take action on my directions.
I believe that's perfectly reasonable. I don't have any impression that DBHDD would go against the fire.
No, I don't either. But you were just saying that then might open up DBHDD to mandamus action, because then the county could point to the fire commissioner's report saying this is what you need to do. Before we turn things over to Mr. Palmer, tell me what would constitute a clear legal right to relief in this context. What would be in Title 8, Chapter 2, where it talks about the state adopting the ICC and statewide application? What in there, because you're saying it's not sufficient, and I'm not really focused on the Milledgeville ordinance, and certainly the ICC itself can't say state of Georgia. It would have to be some state enactment. So I'm particularly focused on Title 8, Chapter 2, where it talks about buildings and requirements that are statewide. What kind of language, and you don't need to wordsmith it, but generically, what kind of language would be sufficient in there that Mr. Palmer could hang his hat on, and you'd say, oh, look at that, the states waived it.
My personal favorites are the Tort Claims Act and the breach of, and the waiver of sovereign immunity for written contracts. Pretty clear. You know, we waive sovereign immunity for purposes of written contract. I think it's 5113.
Right, and it's explicit, and that's easiest for judges and for litigators, but is not the case law rife with situations where courts have said, you know, it doesn't say explicitly, but by application, this by implication, or the only reasonable way to read this statute is that the state has waived sovereign immunity. So ideally, to make clear for everyone, it would say somewhere in Chapter 2 of Title 8, and the state is waiving, either this applies to the state as well, and we waive sovereign immunity to any claim. It doesn't say that. But what kind of enacting language would give you reason to pursue less vigorously a sovereign immunity claim?
The court, I think, nailed it when it used the word implied waiver. There are no implied waivers, and clear, plain, and unmistakable language. If I was a legislator saying these things apply to state buildings, I would try to say that directly out loud, you know, and as clear language as I could.
As opposed to statewide application, which just means it is a building in Georgia. In theory, it's governed by this, but there may be carve-outs like sovereign immunity.
Like state-owned buildings.
Yeah.
And I think if I were to do that, I would try to synergize the entire code, as complex as that may be, and look at Chapter 25, which clearly says the counties don't enforce it. It's these codes are enforced by the state fire marshal. To the extent I was going to waive the state's sovereign immunity for purposes of Chapter 8, I would try to I would go through the code and find Chapter 25, which clearly says the opposite.
Okay.
This isn't answering the court's question, but I'll give you the opposite of it, which is a situation in which the court specifically says, listen, we're not waiving sovereign immunity on this. That's Title 8, forgive me, Chapter 8, Title 3, which applies to existing buildings, not newly built buildings, but existing buildings that have been in operation over 5 years. In that section, there's an explicit statement saying the sovereign immunity is not waived for the state with regard to these existing buildings. And that was done simply because for this purpose like this, for the existing state buildings, and these are all existing state buildings,
right?
So that they would not be subject to suits like this, you know, claims against the state buildings for that.
Why aren't you invoking that provision that these buildings are ancient compared to just 5 years? Or it's because they're unoccupied?
Well, because it wasn't raised in the third amended complaint. Chapter 3 does deal with existing buildings. We referenced it in our brief, but it's not raised in the complaint.
Okay.
So to the extent that these are existing buildings and that's applicable for that reason, then there's an explicit failure or explicit refusal to waive sovereign immunity on it.
Okay. So. And that statutory provision?
It's
because you've been using chapter and title, I think, differently than I do.
Yeah, because I'm frankly, wrong and don't know the
Okay.
difference. Your Honor, for the record, I want to correct the regulation. It's 120-3-3-.03, which adopts the codes. It is the chapter with regard to existing buildings, title/chapter, is OCGA 8-3-200 at sequence, particularly 8 I have in my brief, which may be a mistype, 8-2-222, but I think it may be 8-3-222,
Okay.
which is a provision in which the state does not waive sovereign immunity with regard to these codes for existing buildings.
Yep. All right.
All right.
Thank you,
I have to
sir.
reserve a few moments if necessary.
You have a few moments,
Thank you, sir.
probably. We'll see. So you already got to give your argument when I asked you the question about the municipal ordinances. Do you have anything you want to add?
Just a little bit, Judge. Your Honor, may I approach?
You may.
Your Honor, that was Exhibit B attached to our complaint, if you'll recall. And why are we here? This case has always been about saving lives, not mere little building remarks. This is about firefighters, first responders, and citizens of Baldwin County. There are serious issues with these buildings. We've alleged.
If I went to Milledgeville with you next week to check out Central State Hospital, could I get on there, or would I need a key to unlock a gate because it is not an accessible space to the general public?
Your Honor, I handed you Exhibit B, and I've
did.
tried to mark the pages there. So if you'll flip with me, you'll see on page 1, I'll just go through them in order, but I will address your question. Exhibit 1, you see there several of the windows. Some of them have already fallen out. Several are ready to fall out there at the top or the middle. Page 2, closer up image, you can see again where the windows have actually fallen out. You can see all of the vegetation that's overgrown. I believe this building as well, the roof has partially collapsed in as well. Page 3, this is in response to your question. These are just random trespassers who are able to go into and out of the building. That is what we are complaining about. You have these buildings that are unsecured to the public, to where you have students who go in there because it's been published online that it's a cool ghost hunting.
But I see that picture, and I'm taking your word that those aren't inspectors crawling through that open window.
That's right.
To get there, did they have to vault a fence, climb, or literally I could be walking down Main Street and I turn left and it's an open driveway and I am able to access, I mean, this picture
Absolutely.
1 looks like something from a zombie movie. But that I could just get there not having to traverse something that would say to the reasonable person, you're not allowed in here.
We were able to drive right up to the front door, Your Honor.
Okay.
Page 4, there you go. There's an open door. Page 5, there's another open door. Page 6, you can see the structure collapsing there, along with more overgrowth, all the debris in the building. Page 7, you can see this is the state of the buildings where everything was just left in these buildings. And I'll go into a little bit more detail. Same thing with page 8, just files, records, boxes thrown everywhere.
Seems like a movie studio would pay a lot of money and could solve everyone's problems if you just lease that out to Pinewood Studios or something. Fascinating looking area. Thank you for sharing those pictures.
Well, except for the fact, Your Honor, that any movie studio would have to go through an extreme amount of work to get those buildings safe to even go into.
They'd have to reach out to the fire marshal.
Your Honor, well, if they were to buy them, then it would be their duty. Right now, they're owned by the state in the custody of the Department of Behavioral Health. It is their duty and responsibility. So what are we talking about? Again, there's open elevator shafts, which is dangerous in 2 ways. Number one, many of these areas where there's open elevator shafts, 3, 4 stories, are dark. So there's a hazard of first responders falling in, as well as our inspectors have noted, when you have an open elevator shaft, it creates this chimney effect. So let's say a fire were to start on the first floor, it quickly expands up through the elevator and lights the whole building on fire. There are combustible and explosive materials kept in these buildings that were noted to be hazardous materials, including biohazardous marked waste containers and used medical needles left all over the floor of some of these buildings. There were also noted to be interior doors that are bolted shut. So you can imagine a situation where there are firefighters in these buildings for an emergency and they run into an interior door that they can't get out of. That's disastrous, Your Honor.
So a couple things. One, I'm not doubting at all that this is dangerous. I personally wouldn't want to climb around in there, unlike those spelunkers. And it sounds like it would be super dangerous for a first responder who has to come because a building caught on fire and they can't just watch it burn because it could spread to somewhere else. Assuming all those things are true and well demonstrated, let's shift to the,
Yes, sir.
so what do we do about it? But you've helped me understand why Baldwin County remains concerned. And that would be on multiple levels. Like, well, now we have to provide fire services here if DBHDD or whoever might be responsible under the contract is pulling back on that. We'd have to do it, and that's putting at risk the lives of Baldwin County fire suppression personnel.
Your Honor, this is the defendants, because remember, this is a writ of mandamus. It's brought not against the department, it's brought against Defendant Tanner in his official capacity as the commissioner of the department. This is their 6th iteration of a motion to dismiss. We've only filed 3 amended complaints. There's been 6 iterations of a motion to dismiss. And we'd ask that you deny this latest iteration for 3 reasons. One, as this court previously held in its order, and from May of 22, or I forget if it was last year that this case has been, but this court held sovereign immunity does not bar claims for writs of mandamus. It's that simple. Number 2, the international codes, fire, building, and plumbing are enforceable against the state and do apply to state-owned and operated property. And number 3, Baldwin County does not have an available alternative legal remedy which is equally convenient, complete, and beneficial to the county. Your Honor, counsel for the state got up and first argued that it's an issue of sovereign immunity. As this court is well aware, sovereign immunity is always a question of subject matter jurisdiction under 12b1. Then he kind of wavered and said, well, it's really a question of 12b6, and then concluded by saying it is 12b1. So I'm a little confused, but I'm going to argue both sides of the coin there. The only issue is whether sovereign immunity has been waived for a claim. What is the claim that we've brought? It is a claim for a writ of mandamus. That's all we have to address when we're addressing a 12b1 subject matter jurisdiction and the question of sovereign immunity. There's nothing that the state has cited to which says that not only do you have to show a waiver of sovereign immunity for the statute that says you're entitled to a writ of mandamus, but also the statute or code that provides the legal duty that you're seeking to enforce. There's no authority for that. And it doesn't make logical sense. If there was a waiver of sovereign immunity for the statute that creates the underlying duty, then there would be an alternative cause of action that you could bring. That's the whole reason the mandamus statute exists, is because there is no other waiver of sovereign immunity. There is no other claim you can bring. So you bring a claim for a writ of mandamus to compel an official to fulfill their official duties.
So then let's jump to no adequate relief available. And there's really several facets to that question. Mr. Legel described in helpful detail a channel that exists that's working with the fire commissioner or fire marshal. So one question is, why isn't that adequate? And then a related question is, why wouldn't you start there anyway? I appreciate the notion that these are DBHDD buildings, decrepit as they may be, and so you would turn to Commissioner Tanner. But all the examples you gave were fire, harm, things that I think, but this is a fire commissioner situation, state fire commissioner, not if there is one in Baldwin County or one in Milledgeville. So it's sort of two reasons why your client isn't reaching out to the fire commissioner. One, because it appears like that would be not just the appropriate, but an adequate channel for relief. But two, subject matter expert. It's not me, certainly. And it's not Commissioner Tanner. He knows a whole lot of stuff, but it would be about Central State Hospital if it were open and running, and how to operate it efficiently and care for the clients who are there. But in terms of open elevator shafts and backdraft and this and that, it's really not whose door I would think one would start with, other than the fact that it says on the front door, property of DBHDD. But what it really says is property of the state of Georgia. So take it from there.
Your Honor, it's not me who's imposing the duty. The General Assembly imposed that duty on the commissioner. That's why the commissioner is to be held responsible. It is his duty to keep these in compliance. It's nobody else's. He's the only one that we can bring this claim against. Your Honor, I would like to note that there was a new provision, and I didn't even get the record site, where counsel's now saying that there is a whole avenue for judicial relief. That was never cited in their brief. They're trying to amend their motion to dismiss yet again. So I would ask for the opportunity to be able to brief that and review the statute.
You're talking about, and I may have dragged Mr. Legel there. I don't know that he led with that so much as I pushed him there, but one, of course you can respond. I'll give you time to do that.
Thank you.
But you're referring to what Mr. Legel described as, I think it's 25-2-10, where if the county did go through the fire commissioner channel and said, here are things you need to fix, and they were dissatisfied with what he did or his failure to do things, they could then bring suit in a superior court. You're talking about that?
Yes, Your Honor.
Okay.
Because the only thing that was cited to in their brief, that there were two arguments on this point. One was they said that the county has an alternative avenue and that these codes are enforceable by the state fire commissioner. And two, they said you can file this report with the commissioner citing to 25-212A3, but there was no mention whatsoever of an avenue by which you could appeal through the APA or to superior court. And Your Honor, I would like the opportunity to review. I believe you said it was 25-2-10.
Well, I said that because Mr. Legel said that.
Okay.
I'm not doubting him, but I guess my reaction is the state laid out this alternate adequate remedy, which is knock on the fire commissioner's door. It sounds like maybe they didn't spell out every step of that process to include the ability to appeal and get into superior court. But I'm not viewing his answer to me saying, well, what happens if the fire commissioner doesn't make you happy? He answered my question. The fact that it's not in their brief doesn't mean I wouldn't have bumped into it either, in considering it, to say, boy, how adequate is this? It's pretty darn adequate, because if you didn't like what the fire commissioner either did or directed the commissioner at DBHDD to do, you can get into court with it.
Judge, this is why it's their burden. They filed the motion to dismiss. You can only consider the things that they raised in their motion. And they did not point to anything other than you can send this report to the state fire commissioner. The standard is,
I'm pretty sure I could take judicial notice of what, assume 25-210 says what Mr. Legel represented. You're telling me that I couldn't rely on that in ruling on the motion to dismiss because they didn't cite to it?
I don't think that would basically be sua sponte dismissing, because you found a provision in the code that says you have this other alternative that was not raised by the state. So I would object to that, Your Honor, and ask to be given an opportunity to review that statute, because my hunch is that if there is a statute that affords anyone any kind of appeal of a decision from the fire commissioner, it's someone who's cited to and who the fire commissioner is enforcing the codes against. That makes a lot more sense than someone trying to say, oh, you have a duty to enforce, you didn't enforce, and therefore somehow I'm able to appeal that decision.
Well, and we got there in our discussion, you were listening, and so it could well be that the ultimate challenge isn't against the fire commissioner. Of course, if the fire commissioner declined to take action, that's who the county would be fussing at. You need to look at this stuff, and your conclusion was that this all meets code. We know it doesn't, and we're going to take that up with the court. If instead the fire commissioner said, by golly, you're right, Baldwin County, these changes need to be made. Commissioner Tanner, you need to do these things. Mr. Legel didn't concede that that would be necessarily sufficiently fertile grounds for a mandamus, but his words were along the lines of, that'd be pretty hard to defend against if Tanner did nothing in response to King saying, this is a disaster and you need to fix it. Because it's not King's job to fix, it's King's job to identify what needs to be done, and he hands it over to the Department of Revenue, to DBHDD, to Department of Corrections, because the cell doors are falling off.
A couple points, Your Honor. Number one is, again, the only remedy afforded by the statute that they've cited to in their brief is you get to submit a report. That's not complete. That's not the same level of complete relief that we can get from a writ of mandamus, where there's actually an order saying, Commissioner Tanner, you have this duty to go comply with the International Fire Code, and I'm issuing this writ of mandamus compelling you to do so. Number two is, Your Honor, the state wants its cake and to eat it too, because if you'll recall, they argued and got this court to rule that there's no contract in place. There's nothing that would authorize, under this court's ruling and what the state's arguing, the county to go and do a fire inspection, because the supplemental powers clause says, county, you can provide these supplemental powers, fire protection in the unincorporated area. City, you can provide it within the city unless there's a law that says otherwise, and unless there's a contract. And Your Honor said that there's no contract. So the state can't argue there's no contract, and at the same time, well, you could go and do this fire inspection and therefore go through this remedy. Just so we're clear though, Your Honor, we have appealed that. We do believe that there is a contract, but as it sits
you
right
waived
now,
nothing by saying I ruled the way I did. You've already let me know what you thought about that ruling.
That's right, Your Honor. All right. I believe that, has that addressed your question about the point being that there's nothing that we could do. Let's say we are able to do a fire inspection. We submit a report. Fire commissioner doesn't do anything. Okay. There's no absolute duty for him to do something, to bring an enforcement action. No more than if I'm representing a criminal, a victim of a crime, can bring a mandamus against a district attorney and say, you've got a duty to enforce the laws and you haven't brought an indictment against this person.
Wayne Kendall's trying to do that right now. We'll see what happens.
Well, as of right now, there's no law that affords that, Your Honor. That's a discretionary duty, and that's why, again, all right, let me just kind of backtrack now, Your Honor, and address the other argument, which is that the county has an adequate relief because the fire commissioner could go and enforce these codes. That's not a remedy that's afforded to the county, right? That's enforcement authority given to this other entity, and that's not sufficient. We've cited to, and the state cited to, Blaylock versus Cartwright, 300 Georgia 884. That's 2017. If Your Honor doesn't remember anything else, I'd ask you to go and read this case. In this case, there was a suit brought for writ of mandamus to compel a mayor to comply with a citizen's open records request. The Supreme Court said to preclude mandamus, an alternative legal remedy must be equally convenient, complete, and beneficial to the petitioner. What did the mayor in that case cite to? He cited to an enforcement provision that allows the attorney general to bring actions to impose civil penalties against people who don't comply with an open records request. Supreme Court said that's not sufficient. Just because it's available to this other entity does not afford you the same relief that's equally available to you. So the remedy must be available to the petitioner itself, and there is no remedy available to the county which is equally beneficial and complete. And that's in all the state's cases, Your Honor. They cited to Sauter v. Stevens, where they said, the court said, appellants must also show that they have no alternative adequate remedy at law. That's the appellant itself. Georgia Department of Human Services versus Addison, they found that the plaintiffs did not exist their available administrative remedies. It's personal to the person seeking the writ of mandamus, and because the county doesn't have an adequate remedy, it is entitled to a writ of mandamus in this case. Your Honor, I think the reason that there's this back and forth about 12B1 versus 12B6 is because there's an attempt to improperly burden shift. 12B1, it would be our burden to show a waiver of sovereign immunity. We've done that. We've said sovereign immunity, it's been clearly held, does not apply to a claim for writ of mandamus. 12B6 is different. It's no longer necessary for a complaint to set forth all elements of a cause of action. If within the framework of the complaint, evidence may be introduced, which will sustain a grant of relief to the plaintiff, the complaint is sufficient. We've given them more than adequate notice, Your Honor, of the claims.
But what is your claims are clear, but tell me what you think exists that establishes the clear legal right. That's what Mr. Legel focused on. And that was his shift to 12B6 from 12B1. Sure. And there was some oscillation between the two, but the 12B6 argument, as I understood it, was a failure to state a claim by the county, i.e. identifying the clear legal right that you were seeking to vindicate. And so that's when I engaged Mr. Legel with, well, give me an example of what would establish it. And it's the state, I'm not going to say it right, but the Tort Act, where it basically says we waive sovereign immunity. And he showed the reverse, and I've looked it up. It actually is 8-2-222. And it says we don't waive sovereign immunity. So you got that's even the threshold, but the clear legal right that you're seeking to vindicate, where is it in Title VIII or in the ICC? And I hope it's not ICC, because I don't know how the ICC, as it exists as a text, obligates any jurisdiction.
I want to kind of, let me first correct, Your Honor, to make sure we're on the same page. What they're trying to do is say, not only do you have to show a waiver of sovereign immunity by virtue of the statute creating a writ of mandamus, they're saying you've got to also show this waiver of sovereign immunity for the statute that imposes the duty. There's no authority for that whatsoever, okay? So the question when you ask, does the petitioner have a right to the claim for relief, the issues normally, is it a mandatory duty or a discretionary duty? That's the analysis. That's not what they're arguing, because they've basically conceded it is a mandatory duty. It does apply to these state-owned and operated buildings. They've just said, yes, although they apply to those buildings, they're enforced by this fire commissioner or the city of Milledgeville. Does that make sense, Your Honor?
It does in part, because I mean, part of what I'm wrestling with is sovereign immunity in the 12B6 context, because to your point, it's usually this threshold. It doesn't matter the strength of the claim. You can't bring this claim against the state. But we do live in a world where you can bring mandamus actions against the state. What I'm understanding Mr. Legel to say is, sure you can, but there's got to be some clear legal right you're seeking to enforce. And if it's something amorphous, you know what? The state just needs to treat people better. I mean, how are you, and that's, to me, that's distinct from what I'm typically grappling with, which is frankly a whole lot easier. Yes, there's a legal right, but it is not, there's discretion involved. Like this parole, I need to have a parole hearing. Yes, you have to have a parole hearing, but you don't necessarily get parole. I'm upset at mandamus, they didn't parole me. Denied. That's not, they get to decide up or down, but you're entitled to one after X years and you didn't get one. And so I'm going to order the parole board to have that hearing. You do what you want at the hearing, but you got to have it at least. But we're not, that's easy. That's unfortunately, that's not what Mr. Legel is arguing. He's not saying, yeah, you can order us to do an inspection, but you can't tell us how to do the inspection. He'd be right on that, but he's not saying that DBHDD needs to do anything because you haven't identified that clear legal right you're seeking to enforce.
May I approach?
Yes.
Your Honor, I've got some slides here. I'll try to not cover anything but new ground to address your point. So, Your Honor, if you'll flip over to page 3, Your Honor, of the slides that I handed you. So I'll walk you through how, in fact, because I think what you're asking is, can you show that these international codes are enforceable against state-owned property? And how if they are enforceable against state-owned property, how does that connect to Commissioner Tanner, if I understand this court's inquiry? Okay, so 3 ways.
But I think that last one is easy because it's his building. I know it's not technically his, but it's a DBHDD building. And
I've got the statutes to back that up, Your Honor. So first of all, the international codes are enforceable against state-owned property because they were adopted by the General Assembly. They enacted OCGA 8225A, which says on and after July 1st, 2004, the state minimum standard codes enumerated in subset.
You don't have to read all the subdivisions, but they shall have statewide application.
And shall not require adoption by a municipality or county.
Okay.
Okay. Then on page 3 of the slide, Your Honor, we also cited to OCGA because when you look at a statute, you don't read it narrowly. You read them in pari materia with all the other statutes that go to the same subject matter. So you look at the definition for exempted property, Your Honor, and I'm sorry, this is actually on the next page, page 4. But exempted building includes any building owned or leased in whole or in part by the United States. So the General Assembly knew how to exempt a building owned by a government entity. They could have said owned or leased in whole or in part by Baldwin County, by Henry County, by Fulton County, by the city of Atlanta. They could have said the state of Georgia. They chose not to.
So I see that. I'm looking at exempted building, and there's United States ownership, mobile home. And it says any building which is neither mechanically heated nor mechanically cooled. Are any of these buildings mechanically anything anymore? Or really the way you'd apply that would be, yes, there was an air conditioning system in Central State. It's shut down now, but it's not exempted by this just because it's been closed. It was originally mechanically heated or cooled.
2 points, Your Honor, to keep us, this is a motion to dismiss. That would be more of a factual issue, right? So that might be grounds for summary judgment.
Yep.
It's not good for today.
Yep.
But you're right, Your Honor. The fact is these international codes do require there to be air conditioning. So you can't say, oh, well, we happen to not have this that we're required to have in these buildings, and therefore we're exempt.
Okay, but you're right. That's a factual question.
Right. Okay. So that covers, Your Honor, OCGA 8220, which was the General Assembly adopting these codes and saying they have statewide applicability. Next, as conceded by the state, they were adopted by the State Fire Commissioner under OCGA 2524. It's curious because that statute uses similar language, and there's no argument on this side that, well, what do we mean by statewide? what does it say? The state fire safety commissioner shall adopt such rules and regulations as he deems necessary. Such rules and regulations shall have the force and effect of law and shall have statewide application as being the state minimum fire safety standards. So what does that mean? Well, if you're using the term statewide, then it's clear that they have the force and effect of law, Your Honor, and that they do apply to state buildings. Pursuant to that authority, the state fire commissioner adopted 3 rules that I want to bring your attention to. That's on slide 6. Rule 120.33.02 basically just re-emphasizes what the statute says.
Okay, and one of these is the one Mr. Lego was relying on that says that basically the fire commissioner has adopted all of the ICC.
That's 123.303.
Yeah.
Right. So that means that all of those international codes are applicable to state-owned buildings by their own concession, Your Honor. So that's the right to relief. That's how the international codes apply to state-owned buildings. 123.304 says the addition of the International Fire Code, as adopted and modified in this chapter, shall be the state minimum fire safety standards. So then how do you get to the fact that these are enforceable? You go on to page 7 of the slides that I handed, Your Honor. OCGA 25.212C, which says, with respect to every such building and structure owned and operated or occupied by the state, wherever located, the office of the commissioner shall perform those duties specified in paragraph 2 of subsection A of this code section. What is one of those duties under 25.212A2? It's to enforce such fire safety standards. Okay.
So that leaves me with the question of why aren't you banging on his door instead of Tanner's door? This is well done, and I'm following, as is often the case with the way a model code is incorporated in state law. You have to follow a path. You followed it very well. It seems to end at the feet of the State Fire Safety Commissioner.
Okay.
In terms of enforcement, applicability, inspections, et cetera. It clearly doesn't lead to the feet of any other commissioner. Ultimately, they may be on the hook should the State Fire Safety Commissioner say there's an issue here, but it doesn't say Commissioner Tanner or Commissioner X of Department of Revenue needs to make sure that the building is up to code.
So a couple points, and you'll hear, because I tried to address this earlier, I'll try to address it in another way, Your Honor. First off, the only remedy that it affords is a government agency who's able to conduct fire inspections can submit a fire report. Okay, I have not seen anything, and I know the state's raising this new argument today that there's some form of judicial review available to the county, but again, that wasn't in their motion to dismiss, and I would like an opportunity to respond because I believe that that statute would not give the county right to judicial relief. I think it would only apply to, let's say that the state fire commissioner goes and enforces, does an inspection of your home and cites you, and you say, well, I'm complying with the code. Well, then I could go and appeal that decision. I don't think it would allow a complainant to appeal the state fire commissioner's failure for whatever reason to not cite. In this case,
I'm going to give you a chance to look at it.
Okay.
As you've asked.
Thank you, Your Honor. So that's one point. The other point, as I've said, Your Honor, under the current status and under the state's argument, state has argued there's no contract between state and county. So by what authority then, under their argument, would the county be able to go and conduct this fire inspection and submit the reports? Supplemental Powers Clause says counties, you can provide fire protection only in unincorporated area. Cities, you provide it within the cities unless there's a contract between the two of you. Now, in this case, their service delivery strategy allows the county to go and provide fire protection in the city subject to that contract. As long as there's a contract in place between the county and DBHDD, county, you can go and do it to fulfill your obligations under the contract. If there's no contract, county can't do it anymore. So if we don't have the authority to go and do that, how can we pursue this channel, Your Honor?
Okay.
Your Honor, I think turning back to kind of arguments 1 and 2, just to summarize, mandamus is the claim. That's all we've got to show as far as sovereign immunity doesn't apply. Number 2, we've clearly shown in those slides by the statutes and rules and regulations, the international fire codes are applicable to state-owned and operated. And I didn't go so far, Your Honor. I think Your Honor got it, and we put it in our briefing as to how you make the bridge between those are applicable to state-owned buildings to how does that impose a duty on Commissioner Tanner, okay? That's the right to relief, Your Honor. We don't have to show another waiver of sovereign immunity. So we would ask that you find that the county does not have, as the standard was put, we do not have an adequate remedy. There's nothing that provides us the same complete relief that Your Honor can give us by issuing a writ of mandamus. We submit a report. What does the fire commissioner do? He might not do anything. If he doesn't, that's it. It's a dead end. There's nothing else that we can do there. So that's why we've got to come to Your Honor. Thank you.
You're welcome. Mr. Legel, a couple minutes.
Very brief. Do my very best.
Okay. I'll try not to get in the way.
Real briefly, I want to address the exhibits that plaintiff put up in his motion to dismiss.
Talking about Exhibit B?
I will start with Exhibit B, which are photographs. I could be wrong, but from a factual perspective, I don't believe those buildings are the ones that are addressed in the third amended complaint. Third amended complaint refers to 11 particular buildings. Brendan, can you help me out? Are those buildings?
I'm going to object, Your Honor, because the point is that these are the condition of the buildings. Okay.
So just to answer his question, it's not, there's nothing to object to, right? He just asked you a question. Well, you can say I'm not going to answer it or whatever, but I don't need you to, there's nothing to object to.
I believe that some of these buildings are the subject of it, Your Honor. I can't say for certain, and I don't think Mr. Legel can, because some of them are the interior of the buildings.
Okay.
The point being, this is the general condition of those buildings. We're not, again, this goes to the point. There's an improper burden shifting. We're not here today to prove the merits of our case, but that's
but you are here to present relevant evidence. And if this building isn't one of the buildings for which you're seeking relief, this is irrelevant and I shouldn't consider it. And one building might be in terrible shape and the other building might look like a fantastic new skyscraper. I don't know. You represented to me that this is what we're dealing with. And if this is not, in fact, one of the buildings covered, you're not in trouble. But then this, again, would be great for the Last of Us Part 2. But it's not one of the buildings that's at issue. And that's all he's asking. I think that's a fair question.
Your Honor, let me go back because I can cross-reference these with our inspector's notes, and if Your Honor is curious, we can provide a supplemental.
Okay, just confirm and let Mr. Legel know as well. The buildings where we see an exterior in your Exhibit B, it's page 1, page 2, and a few others, are in fact buildings about which you've brought this lawsuit.
And Your Honor, respectfully, again, we're here on a motion to dismiss. This is as alleged in the complaint. These are exhibits to the complaint that was originally filed. The original complaint, we just added additional paragraphs to the third amended complaint. Okay. So you're inquiring into matters for summary judgment. These, as alleged, says these are the condition of the Central State Hospital campus. You've got to take that as true, Your Honor.
Okay, I guess then I'm going to need to make sure you're not misrepresenting anything in your verified complaint. If this, in fact, if the complaint says this is one of the buildings and it's not one of the buildings, you've got a problem. You can avoid that problem by simply figuring out how to answer Mr. Legel's question.
We can figure it out, Your Honor, but
Okay.
respectfully, that is a summary judgment issue. That's the reason, that's the difference between motion to dismiss and motion for summary judgment. I can go and show you pictures of all of the buildings. I kept it strictly to Exhibit B because that's in the pleadings. But we've done our inspections. I can show you many more pictures of the rest of the buildings that I know for sure are subject to this.
Okay.
That would be more for summary judgment. But again, he's trying to improperly shift the burden on us. You're not here today to resolve the questions of fact.
I agree. I agree. And I'm not viewing it as burden shifting. I suspect that none of the buildings is in great shape. But I'll tell you, the way I received this was you presenting to me the buildings that were at issue. And maybe I should have asked you to be more precise, but because I received it that way, when Mr. Lego raised the question of, are these even the buildings that are at issue in the complaint, which is what we're working through on a motion to dismiss, that didn't strike me as irrelevant or as burden shifting. It simply would be, nope, these aren't. These are representative buildings from the campus. Okay, that doesn't weaken your claim. To your point, you don't have to prove anything. But to
sitting here today, Your Honor, I can't say for sure.
That would have been a much better answer. That's all you needed to do, because it doesn't, to your point, you don't have a burden here. And I assume as true the allegations in the complaint. So you're not sure is your answer. Keep going.
We would have to bring our expert witnesses to again, be able to authenticate the pictures. I'm just saying you've got to take what's been alleged in the complaint as true.
Right. And I didn't hear Mr. Lego say, I don't even think these are from Milledgeville. That looks like it's from Transylvania. That wasn't his question, but let's keep going.
And I don't propose that they're from Transylvania. I think they are, in fact, from Milledgeville. Just don't know which buildings, because the Third Amendment complaint refers to 11 buildings, and that's our question. Mr. Palmer also put forth some testimony or some argument about elevator shafts, explosives, biohazards, interiors. I know the court's well aware that we're sticking to the parameters of the complaint. I just ask the court to remember that.
Your Honor, those are alleged in the third amended complaint.
Okay, it's not a back and forth point right now. If it's in the complaint, it's in there. You don't need to worry about it. It'll just make Mr. Lego look like he didn't read your complaint.
That's right.
And to the extent that I waffled on whether this was a 12B1 or a 12B6, I'm very, very sorry. It's a 12B6.
Okay.
Then the last one is sort of the theory that we're traveling under, and I referenced it in the Kelly versus DCH case. Just want to reiterate, there is a case. It's not that there's no case that says you have to establish a clear legal right of relief, and that includes a waiver of whatever immunities apply. Kelly says that. That's Kelly's avenue, and I'll just reply to that. The other one.
So I'm not hearing you say, I don't think, and this is why it's not 12B1. You aren't saying petitions for writ of mandamus, you say it differently, but those types of petitions, they are always and forever barred by sovereign immunity. That's not your point.
Absolutely not.
Which
Correct.
is why you are traveling under 12B6.
That's correct, Your Honor.
Okay.
You got it.
All right.
And then with regard to 25.210 and 25.212, those are the two sections that Mr. Palmer brought up. One about whether any person can bring a claim when he doesn't like the decision of the fire marshal. And the second one was who can provide a report to the fire marshal to get him to do something. They're pretty clear. I can read them to the court.
I've been looking at them. Again, I don't think I'm shifting the calculus at all. I would be remiss if I didn't rely on relevant statutes and relevant case law, even if neither of you cited them in a brief or a motion. And so I have 25.210 right in front of me. Should any person, firm, corporation, or public entity be dissatisfied, ... But I think Mr. Palmer is right in saying, hey, I have a few minutes to digest this and get back to you. And I'm 100% going to indulge him in that. He and I have a disagreement about whether I'm going off the reservation by looking at where Title 25, Chapter 2 takes one if one is knocking on the door of the fire commissioner, which is what your motion says. The adequate alternative relief is to work with the fire marshal and the fire commissioner. That's how I take your argument. Whether you invoked 25.210 or not, to me, is inconsequential. That is the natural extension of pursuing that form of relief. Again, I'll let Mr. Palmer digest it, and he may find some things that can help me understand why, from his perspective, even that isn't adequate. Okay, I'll hear from him on that, but don't think I'm leaving here saying, well, because you didn't cite that, I won't be considering the fact that you can get into Superior Court if you are dissatisfied with the action or inaction of the fire commissioner.
I appreciate that, Your Honor. I'd just like an opportunity to address whatever Mr. Palmer raises.
Yep.
And the same thing applies to, I think, something else Mr. Palmer's probably going to raise, which is Title 25, Chapter 2, Section 12. What entity can bring a report to the State Fire Commissioner? I'll call the court's attention to 25-212A3. Because the question came up was, well, Baldwin County can't do it because Baldwin County doesn't oversee Baldwin County, because those buildings are in Milledgeville.
Right.
Baldwin County doesn't have the ability to bring that report. I would disagree, and I think that statute's pretty clear on that.
Right. I think you alluded to that. You may not have given the specific statutory citation, but early on in your presentation, you said, you know what, local authorities can do an inspection and use that inspection as the lever to pull to get in front of the fire commissioner.
That's correct, Your Honor.
Okay.
And while I don't have a case to cite on 25-212A3, I would say that the way I read it is that Baldwin County could show up in the city of Atlanta, inspect the building, and provide a report to the fire commissioner on it if that's what they wanted to do.
Right. The mayor of Atlanta might have something to say about that, but that's how it reads. My guess is there are not going to be a lot of cases. You guys are plumbing the depths of some obscure, as you pointed out. I mean, if you look at Title 8, that hardbound book hasn't been revised in a million years. So it just doesn't get a lot of attention, but it doesn't mean, one, I can't look at it, or two, it doesn't apply in this situation.
And then finally, we talked about statewide application. We reiterate the fact that statewide application isn't a waiver of sovereign immunity. And to the extent that it is in the fire marshal's code in Title 25, it has the same meaning. We're not saying that those code sections don't apply to state buildings through the fire marshal. Okay, I'll make that concession. We're not asserting sovereign immunity on that.
Okay.
So, and that's
Got it.
really all I wanted to clarify. If there's any other questions.
Nope. I have two questions for Mr. Palmer. One is, how much time would you like and it can be a letter brief. You don't need to go crazy with it, but I'll give you as much time as you want. I know you are anxious for progress here, to get to me, and that would just be an email to Ms. Niles, obviously copying Mr. Lagle and his team, your thoughts about 25-210, et cetera.
I should be able to do it by next Friday, Your Honor. If something comes up, I'll
just let us know.
Yeah.
And then a couple weeks for you to respond, or in a day or two say, I don't have anything to say beyond, Mr. Palmer made some good points, but we rest on what we've said.
Understood.
And if you want to make it a pleading and e-file it, that's fine. But a email with some bullet points is also fine. Your comfort level dictates. That's number one. Number two, there is a discovery question floating around. I think that Baldwin County wants 6 more months of discovery. I think, Mr. Lagle, you all had said we really take no position on this. We don't oppose it. We're not asking for it. And I'm open. We got a couple minutes to work through that. I don't want anyone to think, gosh, we couldn't engage in discovery. Obviously, there's a motion to dismiss swirling around, so I wouldn't want folks to invest too much in it in case I put the brakes on things again, and you can appeal. But tell me what you wanted time for, and I think it was 6 months.
So, Your Honor, if you'll recall, on November 17th, 2023, we noticed the deposition of Commissioner Tanner. Mr. Lagle emailed Your Honor's chambers and asked for a telephone conference.
Right. I remember this.
We held a telephone conference where Your Honor strongly suggested that we take the 30B6 deposition of the department before taking the deposition of the commissioner. We took Your Honor's strong suggestion. I just want to reiterate, during that telephone conference, defense counsel readily identified 2 or 3 witnesses. He said, these witnesses are going to have all this information. You know, we can produce them. They'll be ready to testify. So December 15th, pursuant to your suggestion, we sent a list of topics, 30B6 topics, to the defendant. Didn't hear anything. We're here more than 2 months later, and they still have not said, these are the witnesses. These are when the witnesses are going to be available. The only correspondence we had was an attempt to negotiate the topics, said we have issues with the topics you want to ask our witnesses about. We marked those up, sent those back. And then later in January, one of the witnesses, they said, had some sort of an emergency through February 10th. Here we are today, Your Honor, still haven't heard anything. So it's been floating around for 2 months. We tried to abide by your suggestion, and we just want a timeline set forth by Your Honor as to when they have to identify these witnesses and give us the opportunity to depose the department.
Sure. So it sounds like you ultimately did get a response from, I'm again calling the state, based on your list of topics, but it was, we've got some concerns about these topics.
And we responded, didn't hear anything back, Your Honor.
Yep.
They say that they're still working on the availability of their witnesses. We haven't gotten any witnesses identified, haven't heard anything more about the availability, even though we are now almost 2 weeks past the February 10th date.
All right. I just want to make, because what you started saying was, we've heard nothing, but it turns out you did hear something. It was, we don't like some of these topics, and you got back to them. So they haven't identified anyone, but it sounds like they did identify someone, but then that person had some unavailability. And as of today, February 21st, many months after our teleconference, you haven't had the opportunity, not for want of trying, to depose anyone.
That's correct, Your Honor.
Okay. Response.
Your Honor, there's a lot of facts in that are true. I have not issued a date. I've not provided a date when our witness is available. I've identified him. I identified him in our conference. It's Greg Hoyt. He is experiencing, not he, his grandson is experiencing some medical issues, and he was not available until February 10th. In January, the court reached out to us and said, we're not going to issue a discovery order until after this hearing today. And that's what we're waiting on the discovery order. As a practical matter, I've got a topic list of 45 topics that they want to discuss with a 30B6, and they're aggressive, and these are communications between counsel, but we're preparing for them. They entail a significant amount of preparation, detailed stuff that would be in the international construction codes. To the extent those claims are no longer necessary to be addressed by an order from this court on a motion to dismiss, it would probably shorten this and make this person available a lot faster. As it stands, he's got to go inspect those buildings a couple times.
Mr. Hoyt continues to be the person you identify as the right, we'll call it gatekeeper. Of course, in the end, Baldwin County could still say we need to talk to Commissioner Tanner. I gave my perspective on that. I appreciate that folks are following it for now, but the process would be Hoyt first, and it could well be that if that deposition happens, that gets Baldwin County everything they need. They might say, we still need to talk to Commissioner because, and they'd explain why, and you'd make that happen.
That's, we might
have another conversation.
Okay. Yes, absolutely. We would, if the court gives us an order, we make that happen.
Okay.
But as it stands, I would suggest that maybe this 30B6 isn't appropriate until we get an order on the motion to dismiss, simply because we can, I mean, we're looking at 45 potential topics. I've highlighted a number of them that I think wouldn't be applicable if there's no international code claims in the complaint. And I suggest that. But that said, if the plaintiff would like to go forward with this, and if the court instructs us to make the witness available, he can be available the week of March 11th.
Okay. Well, why don't we line that up? And if I can get something out before then, it may make it a shorter deposition. It may make it exactly the deposition you were expecting. Can you two confer about place, time, and date that week of March 11th?
Your Honor, I'll have to check, but I believe it's a little convenient, but I believe Mr. Welch already has a leave-in that week.
Okay. But then it could be the week after. What I'm hearing Mr. Legel say is that by March 11th, that's a Monday, I'll be back from spring break. Mr. Hoyt will be ready to go, have been prepped on all that. If before then I issue a ruling, it may be that the prep is quicker and there's not a whole lot of time between now and March 11th. But March 11th at the earliest, not a great week for Mr. Welch.
I need to confirm that.
I hear you. I'm holding you to it, right. But it might not be a great week for him anyway. You are busy lawyers. The important part I heard from Mr. Legel is March 11th onward. And so confer and pick a date. And if you can't reach one, let me know and I'll pick a date and we'll do it here. I'll give you my jury room and that'll be less convenient for everyone, but you can sort out a place and time and date, and it may be the week of March 18th. That just gives me a little more time to get an order out that might help cabin the scope of the deposition.
Your Honor, may I just make a couple statements just to perfect the record?
Hmm?
Number one is that at the time we held the telephone conference in November 30th, when all parties had agreed to move forward with the deposition, everyone was aware that there was a motion to dismiss coming forward. Yet, Your Honor, and the state said we're going to proceed with the 30B6 deposition. So nothing's changed until now. And Your Honor, the topics have been out there since December 15th, and I just reiterate that. But we will look forward to, and can we also make official for the record then, there's only one witness, it's Mr. Hoyt, that the department is going to be identifying to respond to all of the topics?
As far as I know, and to the very best of my knowledge, only Mr. Hoyt's going to testify.
Okay, and if that...
But I can't give you 100%.
No, and if that changes, then Mr. Palmer, you just reach out to me, say, here we go again. And we're going to need more time, because I will keep extending discovery if it's clear to me, and you're making it clear to me, that it's not that you aren't doing your job to advance discovery. That's not what's happened here. So it sounds like Mr. Legel is going to do his best to have Mr. Hoyt be that all-encompassing 30B6. It sounds like it's a pretty expansive list of questions, which you're entitled to get at. And Mr. Legel and his team are trying to confirm Hoyt's the guy for all those. And I heard him say, yep, I think he is. If that changes, he'll let everyone know.
Can we ask when we'll expect to know whether Mr. Hoyt is the only witness?
I have every confidence that he's the only witness.
Okay.
As I stand here today.
But if during the remaining prep that needs to happen so that he can be meaningfully responsive to the questions that plaintiff is forecast is going to be asking, you learn, you know what, he's just going to be reading from a script for these 10 topics. We need to bring in Smith. You would let Mr. Welch and Mr. Palmer know, you know what, it's going to be +1.
I certainly will. And I'll go so far as to say, if there's another person, it is the director of maintenance, and his name is Michael Wong. That would be the only other person I could conceive of being necessary. And I don't think he is, because under 30B6, I get to, the state gets to pick the party that is best to answer the questions.
Right.
I have every confidence it's Mr. Hoyt.
Right.
I don't anticipate changing that.
But if he needed to tap out, it would be Mr. Wong who would be the person filling in on some subset of those questions.
I would imagine so. Yes.
Okay.
Absolutely.
I just want to make sure that we don't run into a situation where we take Mr. Hoyt's deposition as the 30B6 deponent, and then the department comes back and says, well, you know, we have this other witness who can probably respond to this other stuff, to try to duck out of the testimony of Mr. Hoyt.
Sure. So what I'm hearing Mr. Legel say on the record is that he expects Mr. Hoyt to be that person. If you all come in with a 46th topic and Mr. Hoyt's not the right guy for that, and we hear he's not the right guy for that, that's on you and not on the state. So if you are hewing to your range of questions that you've gone back and forth on, I'm hearing Mr. Legel say Hoyt should be it, and maybe it would be Mr. Wong, not a third person. But it sounds to me like the goal is to cram as much as possible into Mr. Hoyt's head so he can be the one person for all that. We'll look for a date on or after March 11th. May not be that first week, but that's because people have conflicts.
That's correct.
All right. So I don't know that I need to enter an order about discovery based on this conversation. If you think, right, I don't remember what's in the record, in part because our case management system is down. Thank you, hackers. If you think I need to enter an order that extends anything, I'm happy to do that. I'm telling you now orally, certainly you've got the ability to compel the appearance of this witness at this deposition, but you're going to jointly schedule it, so it shouldn't be an issue.
And I believe, Your Honor, the reason that we asked for an extension is I anticipate that there will be additional